Do I have the right to flexible or remote work? Imagine this. You've been working long shifts, juggling kids' schedules, or caring for a parent. You ask your boss if you can start earlier and leave earlier, or maybe work from home a couple of days a week. The answer comes back, no, we don't do that here. You're left wondering, do I actually have a legal right to flexible or remote work in the U.S.? After the COVID-19 pandemic, millions of workers began working remotely or on flexible schedules. Some employers embraced it, while others pushed everyone back to the office. The law hasn't fully caught up, which creates confusion for workers who want more balance. In this video, we'll break it down. What federal law says when flexibility is a legal right under the ADA or FMLA. How state laws play a role, what company policies matter, and how workers can advocate for flexible or remote options. Federal law. No automatic right to remote or flexible work. At the federal level, there is no universal law that guarantees workers the right to remote work or flexible schedules. The Fair Labor Standards Act, FLSA, governs wages and overtime, but it does not cover where or when you work. Employers generally control schedules and locations, unless other laws provide exceptions. Example, a worker in Texas asks to work from home twice a week for convenience. The employer refuses. Under federal law, that is legal. There is no blanket right to remote work just because it's easier. The Americans with Disabilities Act, ADA. The ADA requires employers with 15 or more employees to provide reasonable accommodations to qualified workers with disabilities. Flexible schedules or remote work can count as accommodations if they help the employee perform essential job functions. Example. An employee with a chronic illness requests to work from home part of the week to manage medical treatments. If remote work does not fundamentally alter the job, the employer may be required to allow it under the ADA. However, if being physically present is an essential function, for example, operating machinery on site, the employer can deny the request. The Family and Medical Leave Act, FMLA. The FMLA provides up to 12 weeks of unpaid, job-protected leave for eligible employees dealing with serious health conditions or family care. While the law itself doesn't mandate flexible work, some employers offer reduced schedules or remote options as alternatives to full leave. Example, a new parent may request to work half-days temporarily instead of taking full FMLA leave. If the employer agrees, that arrangement can serve as a form of flexible work under FMLA protections. State and local laws expanding rights. Some states and cities have passed laws that go further than federal rules. New York City has a right to request flexible work arrangements law. Employers must seriously consider requests for flexible hours or remote work, though they don't have to approve every request. Vermont requires employers to discuss and consider flexible work requests in good faith. California provides strong protections for workers with family responsibilities, making flexibility harder to deny when tied to caregiving. Colorado protects lawful off-duty conduct, which sometimes supports flexible scheduling to accommodate second jobs. Example, a worker in New York City requests staggered hours to care for a child. The employer must engage in a cooperative dialogue before denying the request. Remote work. After COVID-19. During the pandemic, remote work became the norm for many industries. Temporary federal laws, like the Family's First Coronavirus Response Act, FFCRA, provided emergency paid leave and remote work options, but those have expired. Now, whether remote work continues depends on employer policies. Some companies maintained hybrid models, while others mandated full return to office. Workers often argue that remote work has proven effective, but legally, most employers can still require in-office work. Example: a software engineer worked remotely for 2 years during the pandemic. When the company ordered a full return, he objected. Unless covered by the ADA or state law, the employer could enforce the return. When flexibility may be legally protected. There are situations where refusing flexible or remote work may violate the law. Disability accommodations under the ADA. Pregnancy-related needs, protected under the Pregnant Workers Fairness Act, PWFA, which requires reasonable accommodations. Religious practices under Title VII of the Civil Rights Act, where flexible scheduling may be necessary to observe religious holidays. Retaliation cases, where denying flexibility after a worker asserts legal rights may be unlawful. Example: a Muslim worker requests a flexible schedule to attend Friday prayers. Denying this without considering alternatives may violate Title VII, employer policies and contracts. Even if the law doesn't guarantee flexibility, company policies and contracts may. Employee handbooks, collective bargaining agreements, and offer letters sometimes include promises about remote or flexible schedules. Employers must honor those commitments. Example: a union contract allows telecommuting 1 day per week. If management cancels it without negotiating, that may breach the agreement. Real-world cases. Case 1. A worker with multiple sclerosis requested remote work as an ADA accommodation. The employer refused, claiming presence was essential. The court sided with the worker, finding remote work reasonable because she had successfully done it before. Case 2. A parent in New York City asked for flexible hours to handle childcare. The employer denied the request without discussion. The city fined the employer for failing to engage in cooperative dialogue. Case 3. During COVID-19, an employer ordered immunocompromised workers back to the office. Several filed complaints under the ADA, arguing remote work was a reasonable accommodation. Some cases resulted in settlements. Practical steps for workers. 1. Check state and local laws. Rights vary. Vermont and New York City have protections many states lack. 2. Review your handbook or contract. If policies promise flexibility, employers must comply. 3. Frame requests under legal protections. If tied to disability, pregnancy, or religion, employers may be required to accommodate. 4. Propose clear solutions. Show how remote work or flexible schedules won't harm productivity. 5. Document employer responses. If denied unfairly, documentation helps in legal claims. 6. Consider unionizing. Collective bargaining can lock in flexible work policies. Example: an employee in California requests flexible hours to care for an elderly parent. By connecting the request to caregiving responsibilities and state protections, she strengthens her legal standing. The human side of flexibility. Flexible and remote work isn't just a perk, it's about survival for many families. Parents need it for childcare. Workers with chronic illnesses need it for medical management. Commuters save hours and money. For many, flexibility means staying in the workforce at all. Example: a single father who can shift hours by just 1 hour avoids losing childcare coverage and keeps his job. Without flexibility, he would be forced to quit. The bigger picture. The debate over remote and flexible work is reshaping labor law. While the U.S. doesn't guarantee it yet, momentum is growing. States and cities are passing right-to-request laws. Courts are recognizing remote work as a reasonable accommodation, and workers are organizing to make flexibility permanent. So, do you have a right to flexible or remote work? At the federal level, not automatically. The FLSA doesn't cover it. But the ADA, PWFA, Title VII, and FMLA can require flexibility when linked to disability, pregnancy, religion, or family health needs. States like Vermont and cities like New York go further, requiring employers to consider requests in good faith. The bottom line? Flexibility is not guaranteed for everyone, but it is increasingly recognized as essential. Knowing how to frame your request under existing laws and knowing your state's rules can make the difference between a flat denial and a workable arrangement. If this video clarified your rights, share it with coworkers. Work-life balance isn't a luxury, it's becoming a legal expectation.